Well, welcome everybody. On behalf of the Center for Civil and Human Rights, my name is Jen Mason McAward. I'm the acting director of the center. And we're just delighted that you're here, and we're even more delighted to welcome Ralph Neas to speak to us about the Voting Rights Act today. Ralph is a graduate of Notre Dame and the University of Chicago Law School. He served as chief counsel to 2 different U.S. senators before he became the executive director of the Leadership Conference on Civil Rights, which is the nation's oldest and largest civil rights coalition. Senator Edward Kennedy once called Ralph the nation's 101st senator for civil rights, citing his leadership on numerous federal civil rights laws, including everything from the Civil Rights Act of 1991 to the Americans with Disabilities Act, the 1988 Fair Housing Act amendments, the Japanese American Civil Liberties Act, and the 1982 Voting Rights Act extension. After almost 15 years at the LCCR, Ralph became president and CEO of the nonpartisan People for the American Way and its related foundation, where he continued his civil rights leadership by working on, and among many other things, the 2006 Voting Rights Act extension, which was ultimately declared unconstitutional by the Supreme Court in Shelby County versus Holder in 2012. Ralph then left People for the American Way and joined the National Coalition on Health Care, and as the CEO directed the final push for passage of the Affordable Care Act. Ralph has received countless awards and has repeatedly been named one of the nation's most influential advocates. One of the titles that he values most, and I value most in his incredible resume, is that of Notre Dame graduate. We're grateful that he's here today to share his experiences and perspectives on voting rights. So Ralph, thank you and welcome.
Good afternoon, everybody. It's always great to be back at your alma mater, and as you can tell by Jen's introduction, nothing makes me prouder than to be a graduate of Notre Dame. I don't get here often enough. On occasion, the university has asked me to give lectures on healthcare or politics as a vocation, and I was delighted when David Courtwright and Jennifer asked me to come and talk about the Voting Rights Act. I'll also, if you know my background at all, we'll put it in the context of the Supreme Court, also past and future. But first, I do want to salute you all for being here, and Jen for putting all of this together, and the Center for Civil Rights and Human Rights. Ted Hesburgh, of course, founded it or was responsible for it. One of my heroes and mentors over the years. David Courtwright was my roommate at Notre Dame. 1968. We've changed in many different ways, but one way that you might find amusing is that David Courtwright in 1968 was the drum major for the Notre Dame Fighting Irish Band. I was the lieutenant colonel of the Army ROTC, two rather authoritarian positions, more conservative positions within the Notre Dame family. And I don't think there was one person at Notre Dame, faculty or student, who would have envisioned the careers of David Courtwright and Ralph Neas based on 64 to 68. But much of what we were able to do in the future really was predicated on what happened here at Notre Dame. I was just talking with a couple of people about 1968 in particular, and for you history students, it was a rather tumultuous year for many, many different reasons. But for David and I, it started out our second semester with LBJ announcing he wasn't going to run because of the Vietnam War and all of the opposition. Truly a very unusual set of circumstances and rather newsworthy and demonstrates the impact, perhaps, of what happens when one organizes and puts together coalitions and rallies around a cause and gets champions to argue on behalf of that cause, whether it be a Gene McCarthy or a Robert F. Kennedy. Unfortunately, we had some really bad moments in 1968. On April 4th, one of my other heroes, Martin Luther King Jr., of course, was assassinated. 2 months later, 4 days after we graduated from Notre Dame, we graduated on June 2nd, Robert F. Kennedy was assassinated. And I'm not sure I admired anyone more than the two of them during my years at Notre Dame. A good note, my best friend in the civil rights movement, Julian Bond, who unfortunately passed away a few weeks ago, was nominated to be vice president of the 68th Democratic National Convention. Maybe the only thing good that happened to me that entire year, but something that also inspired me, gave me hope, and I think in retrospect, David and I, we were the beneficiaries of those kinds of challenges, those kinds of moments, as unbelievably horrific as they were. It made us even more motivated to do whatever we've been able to do subsequently. David and I had a fun week together, by the way, in Washington, D.C. last week. We both happened to be at the White House for the ceremony with Pope Francis, who is an extraordinary leader. I can't tell you how much I've enjoyed listening to him. We don't always agree, and some doctrines I would like to address sometime in the not too distant future within the church. Married priests, perhaps, female priests, things like that, as well as some gender and other kinds of issues. But I think he's courageous. I think he's incredibly inclusive. The Beatitudes are probably what I refer to most when I think of my own values and family values. And I'm not sure I can think of anybody on a day-to-day basis who lives the Beatitudes than Pope Francis. So it was a real treat. And then before David Courtwright came back here to his teaching at Notre Dame, John Boehner resigned as Speaker of the House. The guy really had a dramatic impact in his 48 hours in Washington, D.C. It's going to have enormous repercussions. As you know, we haven't had the most civil few years or bipartisan few years, or Congress is capable of compromise. I don't see it getting any better. I'd like to think it might get better. But this is going to be a fascinating few months as we try to avoid government shutdowns, not so much in the next couple of weeks, but December is going to be really, really rough. And I don't think we're going to see a lot of effort between now and the election of 2016 in terms of the parties sitting down and trying to work out some of the more pressing national issues that face us. I've got my principal purpose, again, is the Voting Rights Act. And I do think it's important that I bring up the Supreme Court. I think many of you know that's been an area of interest, and one of the things I was privileged to do was lead the Block-Bork Coalition back in 1987. And I want to give you some sense of that in terms of what the impact was, what happened, how it happened, but very importantly, the Supreme Court role not only in the Voting Rights Act, but issues across the board. And what does this mean for 2016 and beyond, whether it's Shelby County or other things that we care about? And my message to you at the beginning and at the end today is my primary purpose is to share my perspective, but not to the exclusion of certain people in this room. What we want is a good debate, and we want everybody engaged. I'm sure, knowing Notre Dame, it's a good mix of Federalist Society, faculty, and students, as well as people who think more along my lines. But what we want are the best minds working on this and becoming part of the process. A lot of people are a little surprised when they hear aspects of my personal history, and I'll spend just a couple of minutes because it has an impact on what happened at the Leadership Conference on Civil Rights and some of these issues we're going to talk about. In addition to David Courtwright as my roommate in 1968, I actually went to Marmion Military Academy. Some of you may be familiar with it. At that time, a Benedictine military school. Maybe one of the most important decisions I ever made. I'm not sure, if I had not gone to Marmion, I don't believe I would have been able to go to Notre Dame or to the University of Chicago Law School. Notre Dame years, when you think about it, 64, 65, 66, 67, 68, the years that I was there, tumultuous years. Tumultuous is probably a word I'm going to overuse today. But during those 4 years, you really had one of the most prolific 4-year periods with respect to civil rights in our nation's history. The 64 Civil Rights Act, the Voting Rights Act of 65, Medicaid, Medicare, and then the Fair Housing Act in 1968. And at the forefront of it, in the 60s, and for another almost 50 years, was Father Ted Hesburgh. I cannot overstate how much he meant to me during that time and subsequently, whether it was in the Civil Rights Commission, standing up to President Nixon and being forced to resign because he was willing to criticize the civil rights policies of the Nixon administration, or being willing to appear with Martin Luther King in the mid-1960s on a fair housing march in Chicago. Easy now that Martin Luther King Day holiday and a pretty extraordinary consensus on behalf of his legacy. In the mid-60s, it wasn't so clear with a lot of America, and it took courage in terms of his role here at Notre Dame and within the Catholic Church and as a national Catholic leader to do what he did. And the only thing he said was when Martin Luther King called, he said, "What time do you want me?" And he did it and took a risk, but it was totally consistent with his values and his commitments. I actually worked between 1968 and 1995 for Republicans. I was the volunteer for Nelson Rockefeller's presidential campaign in 1968. Then I became chief counsel, as you know from Jen's introduction, to Senator Edward W. Brooke, who was my lifelong mentor and my first boss. And I worked with another Republican, David Durnberger. And then Ben Hooks, who was the chair of the Leadership Conference on Civil Rights, was also a Republican. I was a Republican until 1995. Some of you might have studied or might have experienced what happened in 1994. And Newt Gingrich took over the House, the Senate went Republican, and the Republicans went in a markedly different direction, inconsistent with much of their history after that. It taught me about bipartisanship, about compromise, which is now, of course, a dirty four-letter word type thing to say. People on both sides of the aisle are afraid to compromise. They're afraid that they're going to be primary if they don't do what their base demands. And I think it's one of the things that we're going to have to address in the coming years. But he was protecting the Voting Rights Act, the 1964 Civil Rights Act, reproductive rights, civil rights, human rights issues across the board. Maybe what I remember most, and I was a law student at the time when most of this happened, he took on the president of his own party 3 times in 3 years on Supreme Court nominations, on J. Harold Carswell, on Clement Haynesworth, and on William Rehnquist. And on 2 of those Supreme Court nominations, Senator Brooke, working with a band of moderate Republicans, and there are quite a few of them now, and Democrats, was able to defeat Carswell and Haynesworth. And of course, Rehnquist overcame a filibuster and was confirmed. When you talk about these moderate Republicans, or liberal Republicans, I guess I was, it's like talking about a walking oxymoron. I've been introduced that way. Liberal Republican, Mr. Neas, is a walking oxymoron. And yesterday I was asked a question at David's class and said, give me a Rockefeller Republican or a Brooke Republican that you can work with now. And the silence was deafening, at least for 8 or 9 seconds, in terms of elected officials. You can think of Susan Collins, John McCain, Lindsey Graham. You can come up with Republicans who are willing to work with Democrats. You can't come up with Republicans who you would call liberal or Rockefeller Republicans. I believe, in fact, that the nation, 60% of the nation, is basically a Rockefeller Republican type person. Very progressive on social justice issues and progressive issues regarding the kind of civil rights issues, human rights issues that we care about, but more moderate centrist on economic issues and some foreign policy issues. I hope those moderate Republicans become back into the electoral arena, but it's going to take some time. After my 8 years as a Senate Chief Counsel, I did have an unpleasant experience. I had Guillain-Barré syndrome and was totally paralyzed for a big chunk of 1979 on a respirator for about 75 days, pre-screening on a number of occasions. And it was rough. It was a progressive neurological disorder, which obviously is reversible. But it might have been a decisive moment in terms of where my career was going, whether I was going to stay in politics, whether I was going to continue to work in the civil rights arena, which I had done with Senator Brooke. And after I got out, I sort of had a bit of a sabbatical during 1980, because we've been in bed for 155 days or so. It takes a while to get stamina back and your muscles working and being able to do some significant work. It was one of the rougher years for civil rights, and this is important in light of what was going to happen during the Voting Rights Act and the summer of 1980, Mobile versus Bolden came down, which undercut the Voting Rights Act, which meant that Section 2, if you're going to bring litigation, there would be an intent standard versus an effect standard. Always remember that. Most of the people in law school and Indian history students probably understand the difference between having to prove intentional discrimination or having the opportunity to show that the totality of what is being done by a government entity or by an individual results in discrimination. To do the latter, you don't have to prove that someone's a sexist or a racist. It's just something that's been in place, a governmental policy or an individual decision or a business decision that results in discriminating against minorities, women, people with disabilities, and others. But if you want anything that goes to the heart of civil rights and the distinction between the left and the right, it's probably about intent versus effect in areas of employment and education and voting rights in virtually every single area. When I came back, all of a sudden I was contacted by the Leadership Conference on Civil Rights, and they said, would you be interested in becoming the executive director? We admired your work with Senators Brooke and Durenberger, and would you be willing to take it over? And I had mixed feelings, and I went out to lunch with John Sears, a Notre Dame grad, who was the campaign manager for Ronald Reagan and Richard Nixon. And he said, I was hoping to get you to come with my law firm, but you should go with the Leadership Conference on Civil Rights. And I said, excuse me, you and I don't agree on anything. Why would you want me to go with the Leadership Conference on Civil Rights? And he said, listen, and this is important because this is before it all started happening, the Supreme Court issues, the civil rights battles in the 80s and 90s. He said, my friends who were starting to occupy the Department of Justice, who I hope will be on the Supreme Court, who I hope will be senators and members of the House, they're going to try to undo what your friends have been doing since the New Deal. And it's going to be a big battle over ideology and judicial philosophy and what is the role of government. And I don't like anything that you'll be espousing, but as I said at the very top, I want people like you involved in the debate because there'll be compromises, there'll be give and take, and on either side, we should bring people in. And then he said something, and he should know, considering some of the roles he's played, whenever you have a chance to be on the front lines of history, seize the moment. And I think that's a good message for all of you, no matter what you do at the local or regional, state, national government, whether you're in business or nonprofits, whether you're conservative or liberal or anything in between. If you have chances at any time in your life to be able to make a difference for what you believe in, that's the moment to take advantage of. And it was great advice for me, and it's probably been a mantra, whether it's been civil rights issues or healthcare issues or anything else. LCCR, Leadership Conference on Civil and Human Rights, has always been almost a mystical concept to me. It's the oldest, largest, most diverse coalition going back to 1950, working with President Truman on desegregating the armed forces. It is the coordinating mechanism for all the civil rights activities in Washington on national advocacy, whether it was the '64 Civil Rights Act right up until the present. For me, to see 157 organizations, all the minority groups, African American or Latino or Asian Pacific, Islander, people with disabilities, religious, Jewish, Catholic, all religious organizations as part of the Leadership Conference, all the women's groups as part of the Leadership Conference, older American. We didn't have LGBT people in until the mid-1980s. That was a late development, but they quickly picked up steam with respect to the issues with the support of the Leadership Conference on civil rights. When the Voting Rights Act was introduced, my 7th day on the job of 1981, April 7th, we didn't know what was going to happen. We had just had not only Mobile versus Bolden, we had Ronald Reagan elected president. We had 12 Republican senators taking over the Senate for the first time. It was a revolution, a peaceful revolution with respect to not just civil rights issues, but issues across the board. But we thought we could do it, but we weren't sure how we were going to build the bipartisan coalitions. And I think the operating mantra for anybody working on civil rights issues or issues you care about is try to get the strongest possible bipartisan bill that you can enact into law. You're not going to get perfection. Sometimes it's patient, sometimes it's incremental over time. But sooner or later, because in 1981 and every other year, you have to think, okay, in the House, 218 votes for a majority. In the Senate, 51 for a majority. But you all know, in the Senate, it's 51 for a majority, 60 to overcome a filibuster, and 2/3, 67, to overturn a presidential veto. In the House, yeah, it's 218. It's 290 to overturn a presidential veto. With Ronald Reagan in there, we expected vetoes, and we got vetoes. With respect to filibusters, we expected them. So we had to think at the beginning, 18 months ahead of us, when are we going to have to compromise? With whom are we going to have to compromise? Who can we target among Republicans and conservative Democrats? The Voting Rights Act, of course, was as important an event, legislation in our history, maybe the most effective civil rights law ever enacted. When you think, and many of you probably have seen Selma, which is a very good movie, it wasn't totally factually accurate, but it certainly was dramatic and accurate in many, many important ways about what was happening in our country in the 1960s with respect to intimidation, suppression, with respect to all-white primaries, with respect to at-large elections and primaries. There was everything possible to minimize the impact of blacks in American voting life. Before the 1965 Voting Rights Act, 25% black registration in the South. 3 years after the Voting Rights Act, 1968, it had doubled in just 36 months. That's almost incomprehensible. In large measure, it was because of Section 5 of the Voting Rights Act, which was pre-clearance. If jurisdictions had a history of discrimination and the turnout was consistently low in these localities or states, those states and localities had to submit any voting changes to the Department of Justice. It's like an administrative enforcement mechanism that we have in the EEOC as part of the '64 Civil Rights Act or in the Fair Housing Act. That was the secret to doubling the voting population among blacks during those 3 years. Literally hundreds and hundreds of voting changes that were submitted to the Department of Justice were blocked because they would have a discriminatory impact. Many of them had discriminatory intent, and they had to be redone, resubmitted. Section 2 allows you to go anywhere in the United States, prove discrimination, not again intent, but on the totality of circumstances test, which was a Bob Doe, a conservative Republican's contribution to the 1982 Act. In 1975, Section 203, bilingual ballot protections were put in there. When we got into the House and the Senate in 1981 and 1982, we had to make sure we extended Section 5, overturned Mobile and got the results standard that Bob Doe would be eventually responsible for, and extend 203. We started in the House because you go where you're strongest, and that's where we had the votes. But in the House, we had to make sure, and this is very critical to Shelby, and anything we want to talk about with the future of the Voting Rights Act, those hearings have got to be absolutely perfect, because if you want an extraordinary federal remedy, like the Voting Rights Act, you have to make sure you make the case so that you pass constitutional muster that it's absolutely necessary. We had 110 witnesses before the House of Representatives. Congressman Henry Hyde, a rather conservative Republican from Cicero, Illinois, after 2 months of hearings, changed his mind at a hearing in Austin, Texas, and said, "You've made your case. I'm switching. I'm no longer going to try to block the Voting Rights Act. I'm going to work with you." That was maybe the first decisive moment, and that led to more Republicans, which led to a compromise in the committee in July of 1981 that came out almost unanimously and led to a 389 to 24 vote. You think 389 to 24, we're almost there. We've got a law. And then the Reagan administration, a few weeks later, says, we're going to oppose it. We don't believe in a results test. And the person who was making the case, among others, was a young man who just had clerked for William Rehnquist. And the young man by the name of John Roberts basically put out a memorandum to the Attorney General as to the reasons why the Reagan administration should oppose a bill that had just passed 389 to 24 and would pass the Senate 85 to 8. So was I surprised when Shelby came down and when he authored that decision? Not a bit. Unfortunately, John, whom I have known for a long time, was always among the leaders of what I would call more the right-wing element of the Republican Party, not the Ed Brooke, Nelson Rockefeller part of the party. But that didn't matter because we had good leaders, Republican and Democrat, with Ted Kennedy being at the lead, and we took them by surprise. There were two things that happened that shifted the momentum back to us after President Reagan's decision. Number one, to the surprise of many, Senators Kennedy and Matthias, the Republican sponsor, put the House bill in with 61 sponsors. A very important number, of course, one more needed to close off filibuster. Then 2 months later, in the defining moment of the Reagan presidency, really early on in his presidency, in terms of civil rights issues, something came down, the Bob Jones decision. Some of you might remember this. Bob Jones, January 8, 1982, I know we were going to win, because what the Reagan Department of Justice did was overturn a Richard Nixon decision to not give tax-exempt status to racist schools. It was unbelievable. The entire world was shocked, even those who supported the decision, that the President of the United States would allow the Department of Justice to do it. Conservative Republicans spoke against it. The Democrats spoke against it. What did I do? What did we do at the Leadership Conference? We told you they're out of the mainstream. They have a radically different perspective on civil rights enforcement. Again, this is, and when I talk about the court on board, we're not talking about good versus evil when we're talking about many of these legal issues, judicial issues. These are ideologies. These are fights about the role of the government. But this one was much easier for most Republicans and Democrats, but it enabled us to seize the high ground again and say, these are the guys who almost got you in trouble. By the way, that decision was reversed by the Supreme Court 8-1, 6 months later. But we actually increased our co-sponsorships from 61 to 65. We went into the Senate hearings, we went into the senator markups, and then one of the many reasons perhaps the Leadership Conference wanted me in March of 1981 was because I was a Republican and I was friends with Bob Dole and I was friends with Howard Baker. I had worked with these people and people at the White House, and Ed Brooks said, I will go and talk to Bob Dole and have you meet with him and see whether we can work out one final compromise. Now, you can imagine some elements of the civil rights community having won 389 to 24 and having 65 co-sponsors. Why do we have to compromise again? Good question. But you may have 65, but you do need 67. And in a veto situation, a president, Republican or Democrat, usually can get their best people, even if they're opposed on policy, to support the president on a veto. So I thought and recommended one more compromise, and Bob Dole came up with the totality of circumstances. So what does result mean? It's all these actions, all these circumstances end up in a discriminatory result. And that's when you can take some action and bring the discrimination complaint and hopefully win a Section 2 case. So it gets out of the Senate, but the best moment was having a press conference, I thought, with Bob Dole, and he was late. So this was going to be my first big professional moment as the Leadership Conference on Civil Rights Executive Director with all of our colleagues in the NAA, the women's groups, the Legal Defense Funds, everybody there. And I get a call. It's from Bob Dole. And what happened was better than a press conference. He says, Ralph, I'm at the White House. I'm just meeting with Jim Baker and President Reagan and everybody, and the president's going to support us. I went, holy mackerel, how'd you do that? And he said, well, I told him we're up to 65 in sponsorships, but we'll have 85 after I announce my compromise. And I said to the president, you can either be part of this historic signing ceremony, or you can veto it and we'll overturn the veto. So we all gathered at the White House several weeks later, and we all celebrated the 1982 Voting Rights Act extension. 25-year extension of Section 5, results standard incorporated into the law, extension of 203, the bilingual ballot. I'm not sure it could have gone any better. I don't think it could have been any more bipartisan. and it continued to have a dramatic impact on the United States for the next 25 years. And then 2006 happens. Sensenbrenner, the conservative Republican who'd been our hero in 1981 and 1982, heard about the Shelby decision. And he couldn't believe it because he's the one, just get back on track for a second. Sensenbrenner did respond to the Shelby decision because what he did in 2006 was to make sure, as we did in 81 and 82, we established a constitutional basis for the need for Section 5 and the Section 4 formula. And that meant you had to show that the circumstances in 2006 were comparable in many ways to 1981-82 or 75-70 or 65 and the continuing nature of discrimination. So they had scores of witnesses. They showed that between 1982 and 2006, 700 submissions had been turned down. 800 had to be altered or withdrawn because they wouldn't pass muster. We don't know how many hundreds, maybe thousands, never were given to the Department of Justice in the first place because they feared being turned down. Many witnesses testifying about the need. Much more sophisticated ways of discriminating than in the 80s or the 70s or the 60s, but the same end result. How do you suppress the vote? How do you have various ordinances or laws, whether it's the at-large elections, whether it is prohibiting various kinds of efforts to promote turnout and registration, whether it is suppression? All of the evidence was there. So we get a law 98-0 in the Senate, 390-33 in the House of Representatives. 7 years later, the Roberts opinion, a 5-4 decision, as most of these are, rules Section 4, the coverage section that allows Section 5 to apply to X number of jurisdictions, part or whole of 13 states. So unconstitutional. The criteria does not meet the current standards, does not meet the current situation. It's not constitutional. And Jim Sensenbrenner goes, we made the case. And if you read the appellate court decisions, they say they made the case. There is discrimination. This formula works. Section 5 works. Section 2 works. We just did this almost unanimously. You would think there'd be deference to Congress on the basis of the hearings and a 98-0 vote and a 390-33 vote. But no, did not happen. Within days, many of the jurisdictions immediately reintroduced and passed things that had been rejected by the Department of Justice, whether it be voter ID, whether it would be provisions that eliminated same-day voting, eliminated early voting. This was happening immediately. There are some bills, and now the North Carolina law is before the Supreme Court, that did all of the above. It was unbelievable. It was not just voter ID, not just same day, not just early voting. All these different things were part of a North Carolina law that would have been automatically objected to by the Department of Justice. So Jim Sensenbrenner and John Lewis, whom I think you've heard of, I'm sure, John Conyers, Pat Leahy, and others, put in the Voting Rights Act Amendments Act and the Voter Advancement Act and would address this and basically accepted the language of Chief Justice Roberts and that we would modernize Section 4 so that it would cover the jurisdictions that had voting rights violations within a 15-year period. If they, for 10 years, did not have any problems, then the preclearance would be withdrawn. But it was nearly tailored to address what the Supreme Court did, no matter how much we disagreed with it, no matter how much Jim Sensenbrenner disagreed with it. It had to be done that way in order to overturn it. There's also provisions that anything, this is a national, not just with preclearance in certain states, any change to the voting laws in the last 180 days before election would have to be made public and would have to be shared with everyone in a way that people would be on notice that there were these last-minute changes. Not surprisingly, perhaps to some of you, nothing's happened. Lisa Murkowski, I'm very pleased to say, a conservative Republican, just announced her support for the Voting Rights Advancement Act. I don't want to be cynical, but I'm not sure there will be anything happening this year or next. I could surmise that some people might not want to act if they want to maximize certain kinds of turnouts in 2016 and minimize other turnouts. So right now, the law of the land is we're now without Section 5. We don't have preclearance. We don't have anybody taking these measures seriously in the House and in the Senate. We are in the worst situation in 50 years. This is the 50th anniversary year of the enactment of the Voting Rights Act. This is the first presidential election in 50 years that we don't have protections in place for minorities in this country. I might add, with respect to the Voting Rights Advancement Act, it also applies to people with disabilities, and also with respect to language minorities, which of course was part of the act during the last couple of tries. So here you have the Supreme Court making a decision. And the Supreme Court historically, at least starting in 65, of course, it affirmed the constitutionality of the Voting Rights Act, whether it was Katzenbach in 65 or Lopez, City of Rome, all were consistent with saying it's constitutional. This was a bombshell, not entirely unexpected because those of us who knew what John Roberts had done in the early 80s and where he was. But it still was a shocker. And it does underscore the importance of the court. And what happened after the Voting Rights Act? The first thing that happened after the Voting Rights Act was the formation of the Federalist Society. And by the way, if there are Federalist Society members in here, I salute you. I've spoken at their events. Unbelievably effective. I must tell you, it's a little bit more than a debating society. They really know how to organize. They have a coherent, effective strategy at all levels. And I think they made a decision that, consistent with what happened in the Voting Rights Act, any changes in our judicial situation in terms of the composition of the court or changing laws by legislative actions or whatever it might be, their best chance would probably be in changing the court. And I think that's been the number one priority legally of what I would call, again, the right wing of the Republican Party for quite some time now. In 1986, of course, Rehnquist becomes Chief Justice. Scalia joins the court. Scalia and Bork were co-founders of the Federalist Society. 1987, the Robert Bork nomination. Robert Bork was defeated 58-42, largest margin in history. Robert Bork had a position that whatever a Supreme Court justice disagrees with respect to the precedent, he's morally obligated, legally obligated, to change those precedents. He disagreed with dozens and dozens of Supreme Court precedents, whether it was voting rights, affirmative action, whether it was equal employment opportunity issues, reproductive rights, business versus consumer issues. I could go on and on. Environmental issues. Basic discontent with the Commerce Clause, I guess, is one way of framing it. But there was a strong bipartisan majority. A lot of people said, Ralph, you put a lot of time into that one, as all your friends and colleagues and members of the House and, members of the Senate, the House certainly helped us with it. What do you think you got out of it? I don't see that much of an improvement. And I said, well, just think about it for a minute. Robert Bork would have been against us on virtually every single issue. Who replaced him? Kennedy. Now, Kennedy is not a Ralph Neas type of jurist. I do respect him a lot. Maybe on 20% of the issues we agree, but many of them are important. I happen to believe very, very strongly in marriage equality. I believe strongly in reproductive rights. He has gone with us, usually on a 5-4 basis, on many occasions. Just this year, he voted not only with Roberts on the ACA, the Affordable Care Act, on constitutionality. He was there not only in marriage equality, but on fair housing and on legislative redistricting. That's big-time stuff. 4 big Supreme Court decisions. But the real bonus of the Bork defeat was David Souter, which came 3 years later. And it was obvious, because I talked to the Republicans responsible, they did not want another Bork fight. They wanted someone who would get confirmed, someone who could pass muster. And David Souter, to my surprise, because I had no idea where he was on the issues, turned out to be like John Paul Stevens and others, who was a reliable vote on many of the precedents that had existed for 30, 40 years. And I can't say enough good things about the Republicans who made the decision and about David Souter's positions and everything he did in such a courageous way. If you look at the Scalia-Thomas type judicial philosophy, and when I was at Peak before, we did a report on every single decision they'd ever made and what would happen if they had a majority. And we found out that there would be about 100 Supreme Court precedents that would be overturned if they had an outright majority. Well, they haven't had an outright majority. With Alito and Roberts, they got closer, but for a while, before Alito, Senator Day O'Connor was like Lewis Powell back in the 80s, a decisive vote, sometimes with the civil rights community. And of course, Justice Kennedy, again, not all the time, but he was also there on a number of key votes. And then people did say, well, John Roberts helped me with the Affordable Care Act. And I said, yes, he did, and I appreciate it. But if you read the first 90 pages of the 120-page legal decision, it's the blueprint for the future if he gets one or two more votes on every single issue, because he basically disagrees with how the Commerce Clause has been interpreted since 1937. So he's an incrementalist. Clarence Thomas and Alito and Scalia are all now. We want everything now. John Roberts is brilliant. He's an absolutely brilliant lawyer, and he's going to make sure he's got the votes, and he's making incremental progress. Not as much as the right would like, but he's making progress. This underscores the importance of 2015 and, very importantly, 2016. I said at the start I was going to incorporate the court. I have. But right now I want to just say we've got to think through, again, all sides, what's at stake, what will it mean for the next 10, 20, or 30, or 40 years, depending on who is elected president. I hope everyone lives as long as possible, but we'll have 4 justices in their 80s when the next president takes office. And I think everyone here knows that who sits on the Supreme Court matters, who occupies the Oval Office matters, and 5 people basically decide what the law of the land will be when there are contested issues before the court. A lot of people don't realize that over 70% of the Supreme Court justices that have been confirmed since 1969 have been by Republican presidents. We haven't had a liberal Supreme Court in a long time. We've had a conservative court, but it hasn't gone all the way over to the Thomas Scalia side, but it could. On the other hand, Shelby might be overturned 5-4 or 6-3 if a more progressive justice or two comes on board between 2016 and 2020 or 2024. We have got to make sure, and again, I mean everybody, what's at stake for our constituencies, what's at stake for the country. One of the great quotes that I've heard in the past is to live fully is to be engaged in the passions of one's time. This is why you can get passionate about. This is an Oliver Wendell Holmes quote from many decades ago, and I've always thought about it because it applies to every one of us. It doesn't matter where you're coming from. And it goes back to what I said at the very beginning of the presentation, to be on the front lines of history, to be involved. And I don't mean necessarily in Washington, D.C. It can be anywhere. It can be at Notre Dame. It can be in the county council or the city council. It could be national politics, local politics. But to get involved. There was a great quote by an abolitionist, James Russell Lowell, back in the mid-19th century. And it was, for every person in nation, there comes a moment to decide. We're approaching that moment. I think what happens in 2016 could determine the future of the court and therefore the future of our laws. It could determine a lot of other things internationally and nationally. So my parting message, and I do want to open it up to questions, and I know you may have to leave after 1:30 or this room may have to be vacated, but people who want to ask more questions, I'd be more than happy to stay for a few minutes. But my message to you, and Shelby was a wonderful teaching vehicle, Jen and David, in terms of getting across the enormity of the Shelby decision, the importance of the Voting Rights Act, what the future is with respect to the Voting Rights Act. Again, my guess is it's more dependent on the Supreme Court than on what Congress is going to be able to do. I'm not sure on issues of any national consequences in the coming years. There's going to be enough bipartisanship to get important things done. I hope I am wrong. I hope I'm totally wrong that we can reach bipartisan compromises that move the nation forward. But I think you're going to get a glimpse of the next few years in December when the spending bills and the government, whether it's going to be continuing to run, will be decided. So these are going to be scary times. They're going to be exciting times. But the country really does need you. Really needs you, and no matter where you're coming from, and lots of others joining this epic struggle, this epic battle about the future of the country, the role of the government. So I hope this has been helpful. I'd love to talk with you and answer any questions now and after class, and I hope this is the first of a number of opportunities that we get to spend together. Thank you very much. Questions? Was that comprehensive? Yes, sir.
So understand that the Voting Rights Act has lost some of its luster over the years, and for example, I'm working on the Detroit bankruptcy issues and the use of the emergency manager to take over, essentially a municipality, essentially suppressing citizens' voting rights in the municipality. What is your thoughts on that?
I'm sorry, I didn't hear the end. You're talking about
the Detroit emergency manager situation, where the emergency manager takes over the municipality's government. And how would you think on the national scale, if that practice were to continue from state to state, how would that affect the Voting Rights Act and just voting rights in general?
I'm not that familiar with the issue, but it's basically a manager comes in to manage the city that might be in bankruptcy. Is that the thrust of it?
Yes.
But that's usually a temporary thing because of an emergency regarding the bankruptcy. I think there are definitely some legal issues there. I'm not sure there are Voting Rights Act issues, but there's certainly empowerment issues and who's making the decisions on the basis of what and whom it's affecting and whether it has a disproportionate impact on minorities or anybody else. There are probably some good legal issues there and maybe some Voting Rights Act issues. But that's a little bit outside, I think, of the parameters of what we usually are considering. And my guess is it's a temporary authority to get the city back on its feet. Is that a fair way to characterize it?
Yeah, that's a fair way to characterize it, but it could be an ongoing practice.
Well, that could get into an entirely different area. And I'm sorry I don't have the ready answers on that, but are we thinking a Detroit-type situation or a smaller municipality?
Just Detroit type situations, but not just Detroit. Just they can move on to say Chicago or California.
Yeah, I think that presents some really interesting legal issues, and I'd love to think that one through with the help of others who may be more knowledgeable about it. But I didn't think about the Voting Rights Act context with respect to that. But there's some fascinating issues that I would love to think through with you. Other questions? Yes, sir.
What's your response to those against passing an extension of the Voting Rights Act that say it's already served its purpose? It was passed in 1965, and now did you say there's 700? I believe you said there was kind of 700 points of evidence or people brought forward certain types of discrimination. So some people will say that, well, 700, there really aren't that many incidents where voting is being suppressed, it's isolated. I guess what's your response to that people say, it's served its purpose, there's no need to extend it any further?
Even though Roberts did say in the decision that there was discrimination, and he would encourage Congress to come back with legislation that was in conformity with the constitutional test. I do think, whether it was in his memos of 1981 and 82 and the basic thrust of the decision, that he does think that the kind of discrimination addressed by the Voting Rights Act is more a thing of the past. When I brought up the 700 and 800, it was the number of pre-clearance decisions by the Department of Justice, 700 objecting, and remember, we're only talking about a dozen states or so. So 1,500 that we know of is a lot of pre-clearance submissions that were either blocked or had to be altered because they were inconsistent with the law. And what the committees found, not only in 81 and 82, but also in 2006, was the type of discrimination has changed. You certainly had much more violent intimidation and suppression in the 60s and 70s, and of course well before that. And you did have some of the more nuanced, like not so nuanced, but annexations. If there's a city that has been basically white majority, but the black minority, the population is increasing, all of a sudden the city said, we're going to annex these 3 suburbs, which was meant, of course, to make sure that there wouldn't be black elected officials. Annexation is one of them, and now you've got the voter IDs. On the surface, my guess is our initial response is, showing a voter ID, what's wrong with that? We've all got voter IDs. But then if you look into it, who are the people who might not have government-issued voter IDs? They would be disproportionately poor, people who don't drive, or just don't have voter IDs. And many times this has nothing to do with purposeful discrimination based on race. It has everything to do with power. Who's going to be elected? Who's going to be in charge? And if you have certain people who vote a certain way, maybe they vote Democrat most of the time, how do we keep those people from getting registered or from turning out and voting? So what the committee, in very extensive hearings, as I said, they said, listen, it may be nuanced and much more sophisticated, but it exists. And the opposition is in this North Carolina statute to eliminating same day, or eliminating early voting, eliminating Sunday voting. They were all actions by the North Carolina legislature without any Democratic support to make it more difficult for poor people, especially minorities, to be able to register and vote. So to a degree, the nature of discrimination has changed, but the impact and the results of current discrimination is just as effective and insidious as past discrimination. Was that?
Yeah, so then do you think the Voting Rights Act is a proper vehicle to address that, or would it be some new type of legislation be better, or would just leave it to be a case-by-case basis to resolve by the courts with the solution?
I do think that the Voting Rights Act has been extraordinarily effective and is the most important civil rights law. And there are provisions in there that work, and if there are no jurisdictions who are perpetrating these injustices, then they can get out of coverage of the Voting Rights Act. The reason you can't just have Section 2, which is full-scale litigation, it's timely, it's costly, it doesn't have an effect until years after the actual elections. So this has worked well, which is not to say you can't have other legislation that becomes law. And of course, we've not even talked, and this is not the right forum to talk about other issues, whether it's income inequality and other things that beset not only the minority community, but people with disabilities, and virtually most of the country has had a problem there. Those are things, and the greatest disappointment of my years with the Leadership Conference on Civil Rights goes back to Martin Luther King. He said the right to vote is paramount, but also important is once you have the right to vote, is being able to buy the hamburger at the diner. And economic issues, economic opportunity issues have been for too long ignored by all of us, in part because we're fighting all these rearguard actions, in part because of the politics and the people who've been elected in the last couple of decades. But we got to get back to that. Yes, sir.
Thank you for this fascinating glimpse behind the way that power is exercised in Washington. I don't think no matter where you stand on many of the issues talked about today, we've all learned a lot. I think maybe a flip summary of your talk would be the most important civil rights issue of the day is the Supreme Court. And you've seen more presidential elections than a few of us in this room. Have you ever seen the Supreme Court and the role of justices on the Supreme Court discussed well or responsibly or effectively or even with passion by presidential candidates? And do you have any reason to hope that it will be done so in the presidential elections coming up?
Great question. When I was at People4, we did a lot of polling in 2000 about how people would feel about the court as an issue and where they were on it. Remarkably, the American people understand the importance of the court to a significant degree, and to my at least partial surprise, we had a 15% advantage, and we shared that with Al Gore. And I believe there was an initial decision to make the Supreme Court an issue in 2000, and some of the advisors decided not to. There are some indications on both sides, the Republicans and Democrats, that it might become one. I just think, just full disclosure, people in the United States, here's what could happen very soon, and wherever you are, you should know about it, and you should debate it, and you should want your presidential candidates to address the issue. And then we can make a determination who we're going to vote for. But it really never has been that big of an issue. It was probably politically more an issue in the 60s during the impeach Earl Warren stage in the so-called liberal courts of that time. But my gut is, with Citizens United and with the Shelby case, Shelby versus Holder case, it's got potential. The money issue is a big issue. Voting Rights Act, I think, is a big issue, but there are a lot of other big issues out there. I did something, I redid it last night when I was preparing for this, that I did with People4. And if the Bork nomination had been defeated, by 1991, there would have been a 5-4 or 6-3 majority against everything that I've talked about today, because it would have been Bork in there would have been no Souter, and of course Thomas in 91. In fact, because O'Connor and White often voted with the Republican side on a variety of issues, it may have actually been 7-2 with Marshall, not Marshall. I think there were a couple of others who Blackman, of course, and White, I believe, were the last two before the Clinton appointees. But I found it amazing that 70-something% have been Republican appointees. I think hopefully the pendulum is going to swing and give some other opportunities, either to Democrats who will put the kind of people we're talking to, or Republicans who put more moderate centrist type, but don't bet on the latter for a while. Hopefully it will become an issue. We running out of time?
Yeah, I think our time is over, but please join me in thanking Ralph Neas for
Can we stay in here? Or should I just...
There's class in here at 2 o'clock, so if anybody wants to come and talk to Ralph.
Very good.
I think they should have moved these seats to 5 years.
I wasn't sure.
Well, I gotta start somewhere.
The Chipotle
It's hard to 14 issues all I'm saying is, I could come take over.